Acting Jacinda Ardern.
Thank you, Mr Chair. It's my pleasure to take a call on this part 2 of this bill. But I do just want to note that when there was a closure motion called for part 1, and there were those of us who wanted to try and take a call and were disappointed that we didn't have a chance to debate what is an incredibly important bill, that the Attorney General's response to that denial to what I would call a basic element of a democratic procedure in this House was stiff bickies. Stiff bickies was the call. What was it? Was it stiff cookies? Stiff cheese. I stand corrected. I'm glad that that will be on the record. It was stiff cheese. I'm glad we cleared that up. I think the Deputy Leader asked a fine point. Does he wish to further define his type of cheese? It was a blue cheese, of course. Mr Speaker, it's important, though, that we have the chance to fully debate, particularly this section of the bill. I mean, one of my concerns is that even in part 1 of this bill, which we've obviously already closed off our discussions to, but there was a bit of discussion about the types of companies that might be drawn in to our exploration regime in New Zealand via this bill. And, Mr Speaker, I spent a very small amount of time, and like Chris Hipkins, this certainly does not make me an expert in the field, but I spent a very small amount of time working for the Associate Minister of Energy, who obviously has the same portfolios as Mr Bridges now does, and that is around oil and gas exploration and mining. And what I certainly learned in that time, Mr Chair, is that this is a high-stakes game, this business. It's incredibly expensive to operate in this field. And yet we have discussion with this in this bill, which uses language like the use of conditional permits for those who, quote, do not have the expertise or financial ability to operate in this area. And if you don't have the expertise or the financial ability, then, Mr Chair, you will not last in this sector particularly long. And, Mr Chair, nor will you potentially have the success in what is obviously a high-stakes game. Sorry, Mr Chair, I'm bringing you into the debate. So that was just a point that I wanted to make before moving on, that this give-it-a-punt mentality will bring in, I think, the kind of low-grade exploration and explorers that the Green Party has referenced, and that's bad for everyone, particularly when the Labour Party's views on these issues are that until we can give the absolute guarantees that we need, the protections that we need for particularly for deep-sea drilling, that's not a space we're willing to go into. Now, if the government at the same time is opening up for rogue explorers, then that is absolutely not a space we want to move into. But, Mr Chair, moving on to part 2, and Section 55 is the area that I want to talk about. Now, as has been raised, this is the extension of that much protested, ironically, provision that 79% of New Zealanders were opposed to, and that was setting limitations around the right to protest out on the seas, and now out on the high seas, because the change in definition, Mr Chair, that we've seen in here in Clause 14 is in Section 55, new Section 101A, to replace the definition of offshore area with offshore area means any area that is A, within the territorial sea, or B, within the exclusive economic zone, or C, on or above the continental shelf. Now, I wanted to do a little bit of reading about what the definition of the continental shelf is. There was a United Nations declaration signed on the 29th of August 1980. It was a statement of understanding. That makes this declaration I think about the same age as the minister, and that declaration set out a definition for the continental shelf. Now, this is really interesting. The continental shelf of a coastal state comprises the seabed and subsoil of the submarine areas that extend beyond its territorial seas. It is absolutely correct that we have mining rights, according to this declaration, over the continental shelf under Article 76. If we move on, though, to Article 78, which sets out the legal status of the superadjacent waters and airspace, and the rights and freedoms of other states, Mr Chair, it says that, Mr Chair...
Jacinda Ardern.
Thank you, Mr Chair. I did want to get through this UN declaration because clearly this hasn't been explored nearly enough, and I hope the Minister will respond to my questions here. Article 78 of this declaration, which, as I said, sets out the legal status of the superadjacent waters and airspace and the rights and freedoms of other states, sets out that 1, the rights of the coastal state over the continental shelf do not affect the legal status of the superadjacent waters or of the airspace above those waters. And point 2, the exercise of the rights of the coastal state over the continental shelf must not infringe or result in any unjustifiable interference with navigation and other rights and freedoms of other states as provided for in this convention. Of other states and probably of the citizens of those states, because, as this declaration clearly points out, yes, mining rights do exist over, Mr Chair, the continental shelf. But those rights are limited to activities in the submarine area, at the seabed and subsoil of the submarine areas. Above that continental shelf, those same rights do not extend. We're at the high seas point at that point. And as Article 78 points out, the continental shelf rights do not affect the legal status of the superadjacent waters, and it says of the airspace. So this government does not have the right to extend this already much disliked, hated provision to the continental shelf, but it's going to try. And if it's going to try that, then it might as well just go for the airspace as well. Why don't we just have protests banned from the air as well? Anything above the continental shelf, because it's as ludicrous as what they... We could just claim as a territory all of Mars while we're at it, because it's actually about as legally possible. And I mean, even, Mr Chair, this article goes down as far as Article 58 to tunnelling. This part does not prejudice the right of the coastal state to exploit the subsoil by means of tunnelling, irrespective of the depth of water above the subsoil. Again, reiterating, at sea level, at the subsoil level, go for gold, literally. It is the state's patch. You can tunnel it, you can mine it, you can drill it according to this UN declaration. Not advocating that that's what the government do. Don't take that as a challenge. So a protester cannot go in and the government can go in and tunnel. A protester could literally go in and could be banned from tunnelling, but they cannot be banned from doing anything at sea level. That is the distinction that we're trying to make here, Mr Chair. And so the point I'd wish to leave with the Minister is, can he tell the House whether or not this declaration, which, as I pointed out, has been around on this earth as long as he has, was this declaration even looked at? Was there any consultation given to MFAT in drafting these provisions? And the Minister is doing a very good job at pretending that he is not registering any of these questions. Or was this simply something that the Ministry determined we didn't need to look at any of this? Did they just simply decide that what was signed at an international level didn't matter? And is it possible for the UN to ask questions of these kind of limitations that we're now legislating in an area where they have said that we cannot prevent other states, and that might mean a citizen from the United States who might want to come over and protest in our waters. We cannot set a limitation on them, so how can we set a limitation on our own citizens in that regard? And I would ask the Minister to rise and speak to that very important question.
I'm going to call Gareth Hughes.
Thank you, Mr Chair. Kia ora, ngā mihi nui kia ora.